Wilson McKoy, where your work matters. What are your employment rights in an at-will state like Florida? Employment law in Orlando. In an at-will state like Florida, an employer can terminate you from your job for any reason, even for a lousy one, as long as he or she abides by the law. Florida is often labeled as an employer-friendly state. Many employment laws are built to accommodate the employer's needs and concerns over the needs and concerns of workers. However, these rights are not unlimited. In fact, your employer may face civil liability for wrongfully firing you. You may have a claim for wrongful termination if your employer terminated or took adverse action against you, in part because of any of the following reasons. 1. You are in protected status because of your age, disability, gender, national origin, race, or religion. 2. You filed a charge of discrimination or objected to unlawful discrimination, for example, sexual harassment. 3. You filed a workers' compensation claim. 4. You requested or exercised your right to family or medical-related leave. 5. You complained of unpaid minimum wage or overtime. 6. You requested a reasonable accommodation under the Americans with Disabilities Act or Florida Civil Rights Act. 7. You were fired because you were serving jury duty. 8. You reported to a Florida agency a violation of a law, rule, or regulation. 9. You engaged in concerted or protected activity under the National Labor Relations Act or Florida's statutory equivalent. If you have questions regarding a recent termination or layoff, it is important that you know your rights by contacting an Orlando employment law firm. First of all, you should contact a Florida employment law firm as quickly as possible to discuss your options. Whether your employer obviously retaliated against you for complaining about a payroll violation, or you're just confused or concerned about the lawfulness of a new workplace rule, our team can provide you with answers so you can confidently handle any workplace situation. You might also consider carefully documenting what exactly happened and why. Keep copies of any notices, emails, and other relevant communication. Try to write down verbatim quotes and collect statements or even supporting emails if possible without disrupting your employer's daily operations. Simply because Florida is an at-will state does not mean your employer can act with reckless disregard of your rights. You may have more options than you realize to seek a positive outcome. Call or email us today to schedule a confidential consultation. Wilson McKoy, where your work matters.